everyone, welcome back to my YouTube channel, The Virtual Lawyer. I remain Chioma Onuchuku. So today we're going to be talking about notice to quit. Can a landlord evict a tenant, and if yes, how does he go about it? So let me throw this one in for free. When you're renting the apartment or the premises of a person, it's either one of two things, okay? Majorly, it's either one of two things. It's either it's a lease or it's a tenancy. Now, a lease is where you rent the apartment or the premises of a person or even the property of a person. Let's use property, okay? It is when you rent the premises or property of a person for more than 3 years. So 99 years, 80 years, 60 years, all those are leases, okay? Those are fall under the ranges of leases. But a tenancy is where you rent the apartment of a person for less than 3 years. Okay, so you know the difference. A lease more than 3 years, 90 years, and what have you not. A tenancy, it is less than 3 years. So 2 years, 364 days is a tenancy. Although people use it interchangeably, but basically that is the difference in law. At least if you don't get anything in this video, at least you now know the difference between a tenancy and a lease. So the first thing when it comes to notice to quit is to know that there must be notice, okay, emanating from the landlord to the tenant. So the landlord will majorly notify the tenant that yes, he intends to take over or take back his property, okay. But this depends majorly on the tenancy law of your state. So some tenancy laws in some states, some things can say, oh, okay, we're waiving off the notice, but majorly there must be notice. At least that's the basic. You know that no landlord can come into your house and take out your property or start throwing your things away. No, he or she must have given you reasonable notice over time. Now let's talk about content of a notice to quit. So a notice to quit, the first, like, this is the major one, is that a notice to quit must be in writing. So it is not WhatsApp message, it is not a Facebook message, it is not sliding into someone's DM and telling the person that, oh, I want to take my property. No, it's not even you calling the child of your tenant and say, hey, come and tell your daddy or come and tell your mom. No, notice to quit must be in formal writing, okay. You must write down that yes, it's just a formal writing emanating from the landlord to the tenant that he intends to recover possession of his property, okay. Notice to quit must also state the name of the tenant, it must state the name of the landlord or his agent. This must also describe the building, okay, the building where you stay. It must describe it. It must tell you the number or the period or the duration. A notice to quit must also contain the fact that you are a tenant of the landlord. So it must also state that yes, ABC is a tenant of XYZ. Okay, it must state the fact that you are indeed a tenant. It must state the fact that you hold the property for the landlord as a tenant. It also states if you are a weekly or a yearly tenant. These are fundamental when it comes to a notice to quit. So before I continue, guys, come on, why have you not subscribed? So please, I want to encourage everybody, if you've not subscribed to my YouTube channel, please quickly click on the subscribe button you see directly below this video, okay. That's if you're watching on YouTube. But if you're not watching on YouTube, if you're watching on other platform, please do it to subscribe to my YouTube channel at The Virtual Lawyer, and then you can follow me on Instagram at the_virtual lawyer, okay. I would really encourage you to follow me, not because I want followers now, okay. I want followers, but a major thing is that I actually post legal content on my legal tips. I actually post legal tips on my Instagram page, and a lot of people are really benefiting from it, okay. I don't really post this legal tip on the YouTube channel, so I really want you to avail yourself of this opportunity and this information I put out there. So now, that being said, let's get to the business of the day. When it comes to duration of notice to quit, your first port of call should be your tenancy agreement, okay. And that is why we say it a lot of time: get your tenancy agreement, get it. Like, I know you're excited to move into the house, but why not you get a tenancy agreement? You can say, oh, it's my uncle and there's nothing bad there, okay. But it is always safer when you get a tenancy agreement, because you will know the laws or the rules, as it were, that binds you, okay. You know your rights and your liability when it comes to that apartment. So we'll always advise you to get a tenancy agreement. Now, with respect to this, your tenancy agreement will stipulate usually the period of time, okay, that you are entitled to a notice to quit. That in the event of a landlord trying to evict you, you are entitled to so number of days or month or week or whatever, okay. So the first port of call is if your tenancy agreement. Your tenancy agreement will state that ABC is entitled to so number of months, and that number and whatever is stated in your tenancy is what will bind you at that point. Okay, however, okay, no need to fret if there is no stipulated time in your tenancy agreement, or if you don't have a tenancy agreement. There are laws provided, or there are durations provided in the tenancy law in your state. Most of the tenancy laws that I have gone through, okay, they stipulate, some of them have this uniform duration that I would actually state now, but whatever I said now should be subject to the tenancy law in your state. But majorly, these are the duration. Okay, for a weekly tenant, you have 1 week notice to quit. For a monthly tenant, you have 1 month notice to quit. For a quarterly tenant is someone that pays rent like 3 months, okay, every 3 months. And then a half yearly tenant, someone that pays rent for 6 months, you have 3 months notice to quit. And for yearly tenants, you have 6 months notice to quit. Okay, so these are majorly the uniform duration in most of these tenancy laws. Usually you are entitled to 2 notices. Okay, the first one is the notice to quit, and the second one is a week's notice to notify you of the landlord's intention to proceed to court and recover his premises. Now, if you remember, I said you are entitled to 2 notices. Okay, so the first one being a notice to quit, which we spoke about and I've explained. Now, after that duration has passed, okay, let's say for one, you are a monthly tenant and the 1 month has passed, you are entitled to a second notice to quit, which is a 7 days notice to notify you that the landlord is going to court to recover possession. Okay, so like I said, the landlord cannot come into your house even after the notice to quit elapsed and throw away your things. No, after it expires or after it elapsed, a 7 days notice of the landlord's intention to recover his premises is given to you to notify you that yes, your landlord is going to court. Now, what happens is that when you are in arrears of rent, like you are owing, and your landlord has called you on phone, you didn't pick. He chatted you on WhatsApp, you didn't pick. He called your village people, he has called your family members, he has brought wine and drink, he has bought cola, not just to beg you. Okay, not you. Like, he has called to beg the tenants that he or she should pay his or her rent. Now, what happens most times, okay, like I always say, it depends on the tenancy law in your state, but what happens most times is that where the tenant has been in arrears of rent for a period of time, okay, a consistent period of time, like a long period of time, usually what happens is that the person is just given a 1 week notice of the landlord's intention to go to court and recover his premises. I don't know if you understand. So majorly that's it. Like in Lagos, okay, I know about Lagos. In Lagos, if a weekly or a monthly tenant is in arrears of rent for 6 months, usually the court just makes an order. But usually, if you have been in arrears of rent, the landlord has made a lot of pleas and you still don't want to budge, then usually you're just entitled to a 1 week notice of the landlord's intention to go to court. Now, when the second notice is given to you, you have to meet a lawyer to represent you. You can also liaise with your landlord and see how you guys can come to a compromise. But majorly, you're entitled to 2 notices. Like I said, the usual notice to quit and then the 7 days notice of the landlord's intention to recover his premises. Now, landlord, dear landlord, I know tenants can actually be very annoying. Like, we can be very annoying and we are so unapologetic about it. But on no account should you use self-help. Like, let it not even cross your mind, because in a situation where you use self-help, you are actually making the tenants have the upper hand, as it were. Okay, so where you go into the premise or the apartment of your tenant and you start throwing the person's thing, your tenant can sue you for trespass, your tenant can sue you for wrongful eviction or termination or removal from the apartment, your tenant can also sue you for damages. Okay, so you are giving the tenant ways to even start puncturing your rights, as it were. So on no account should you use self-help. Now, let me tell you one funny thing. Another funny thing is the fact that even when you get a judgment from the court, like after going to court and you served your notice and what have you not, and the court says, now after hearing the issue, I have declared, dear tenant, you shall leave the house within 2 weeks. Despite that, you still cannot use self-help. Okay, you have to proceed to court to get like a warrant to execute your judgment. Okay, so majorly the bailiff of the court is the one that can, quote and unquote, use that self-help. You do not have a right to throw the things of you, I know, as annoying as that tenant can be, do not use self-help. You are only shooting yourself in the foot. Okay, there's this funny thing tenants do. When a notice to quit has been served on you, you now say, make I pay small thing. And then probably you now gather, like, you now just raise up to, let's say, 50,000, and then you give your landlord. Dear tenants, I just want to let you know that 50,000 naira you paid does not change anything. Okay, so if you are even paying anything, it only means that you are paying arrears of rent. And when that notice to quit, when the duration stipulated has actually elapsed, the landlord can still proceed to court and recover his possession. Okay, let me explain further. I am owing rent, and let's say I'm owing 100,000 naira in arrears. Like, I've not paid my rent for a while. Let's say my monthly rent is 20,000 naira, and I've not paid in 5 months. That's 100,000 naira. So I'm giving a notice to quit, okay, for 1 month. A 1 month notice to quit, and the 1 month has passed. And then I'm like, deep. Let me now give the landlord something so that he will not throw me out of the house. And then I take, like, let's say 40,000 naira, and I say, Oga landlord, manage this. So you know how the economy is. When it gets to that 1 month, the landlord will still give me that 1 week notice of his intention to recover, or rather, the landlord still has the right to give me that 1 week notice of his intention to go to court. Why? Because what I'm paying is my arrears, not the rent itself. Okay, so the landlord can still proceed. That is why we tell you, when you do stuff like that, always ensure that you are speaking or you are liaising with your landlord that this thing I'm paying, hope the notice to quit will not affect me afterwards, or I'm doing this because you gave me a notice to quit and I intend to stay. Okay, so don't just give your landlord the money and just raise your hand. I'm like, I've settled him. He will see you in court. Always liaise with your landlord, and if possible, if you can get it in writing that the landlord said that the part payment you made is going to waive off the notice to quit, then that's fine. But usually landlords don't actually, they won't board, they won't give you that. They don't do that. They won't do that. But if you have a very understanding one, it's good, actually, it can help you. But then usually they don't. Okay, so always make sure that whatever you are paying, if you are making part payment after a notice to quit has been served on you because of your rent, okay, if you notice to quit has been served on you because you're in arrears of rent and you pay something, ensure that the landlord is going to waive the effect of the notice to quit for you, and usually get it in writing. Okay, so when you're giving a notice to quit, it's either one of three things. Okay, you have to decide either one of three things. Number one, stay.
Oh yeah, you come to stay forever.
This happens usually when you like the apartment. There's regular power supply and what have you not, and you still want to stay in the place, like, I really like this place. Okay, so what you can do is you can meet your landlord, you can liaise with him, see if you can get part payment or a different payment plan, as it were. It's better when you have a very understanding landlord. So if you have a good landlord that you can liaise with, you can just talk to him. But if the landlord still does not agree, there's another way. Okay, when you go to court, you can actually, through your lawyer, okay, you can tell the court that you still intend to stay, and not like the court will force the landlord to keep you in his premises. Okay, but then the court can actually influence the landlord's decision. Okay, but if not, the landlord will just tell you, I don't want, let him just go. Okay, but if you want to stay, those are the two ways. Either you liaise with your landlord, or you tell the court so that they can help you persuade the landlord, not force, persuade. The second thing is, I want to move out. Now, these are for the people that are like, let it be. These are the ones with the attitude that we don't care, we want to even leave. Such a situation, you have to leave within the stipulated notice to quit. Okay, and if you are not living within that stipulated time, you still have to liaise with your landlord and ask him to give you more time so that you can leave the house. Okay, subject to whatever he says. Okay, the third people are those that wants to fight the notice to quit. They feel like their right has been infringed on. They're like, this is unfair. What does it mean? I gave him this. These are the people. That's the third thing. So you can either fight the notice to quit through your lawyer. Okay, you can contest, or you can challenge the notice to quit, and you usually do that in court or arbitration, as the case where, depending on what is in your tenancy agreement. So guys, thank you very much for watching. I really appreciate. Thank you for watching to the end of this video. So do well to give this video a thumbs up, and then if you have not subscribed, please do well to subscribe to this YouTube channel at The Virtual Lawyer, and then don't forget to follow me on Instagram at @the_virtual lawyer. Okay, thank you very much for watching. I look forward to seeing you. Bye guys.